Your Honour, it is my first submission today that Adam is competent to give evidence against Barbara. The first issue that arises from this is that Adam and Barbara are husband and wife. Section 8.2 of the Evidence Act overruled previous law that a married spouse isn't allowed to testify against their spouse. Section 8.2 states that a husband is competent and compellable to testify against their wife. Therefore, Adam is competent and compellable to testify against Barbara. Your Honour, the second issue arising from Adam is that Adam and Barbara are co-accused at their joint trial. Section 8.1 of the Evidence Act states that in a criminal proceeding, each person charged is competent to give evidence on behalf of the defence, but is not compellable to do so. Therefore, Adam is competent. In Callanan v. Bush, it was established that the relationship of co-accused takes precedent over the relationship of husband and wife. Therefore, Adam is competent to give evidence in his defence against Barbara, but is not compellable. Your Honour, my second submission is that Michael is capable and compellable to give evidence against Adam and Barbara. Section 9.1 of the Evidence Act, the presumption to competency presumes that every person, including a child, is competent to give evidence and competent to give evidence under oath. However, the defence may raise an issue with the age of Michael as he is only 5 years old. Your Honour, Section 9A2 states that a child is competent if, in the court's opinion, they are capable of giving an intelligible account of events that they have experienced or witnessed. Michael was under the table at the time of the event and can give evidence on what he heard. In R.V. Brazier, it was stated that competence is a matter of understanding and not a matter of age. It was stated that an infant could be deemed competent if it could give an intelligible account of events. Section 9C of the Evidence Act states that if it is deemed necessary by the court, expert evidence can be given on the child's intelligence, including their perception, memory, expression, or any other relevant matters on ability for the child to give an intelligible account of the events. Your Honour, Michael is a child under the age of 16 years old. He was a witness to a criminal proceeding in an offence that involved violence, and he had a parent-child relationship with the co-accused. For the purpose of Division 4A of the Evidence Act, Michael is an affected child. Your Honour, Section 21(8)(k) states that Michael's testimony must be taken and video recorded at a preliminary trial as he is an affected child. This video is not subject to hearsay evidence, as Section 93A states that any statement establishing the fact of direct oral evidence is admissible in court. Any cross-examination done on this video recording has to be done in compliance with Section 21AH of the Evidence Act. Therefore, the video recording of Michael's testimony is admissible. Your Honour, my third submission today is that Jennifer can give evidence against Adam and Barbara. Section 9A2 states that a child is competent to give evidence if, in the court's opinion, they can give an intelligible account of events that they experience. Like Michael, Jennifer is a child under the age of 16 years. She has experienced a violent crime and also shares the parent-child relationship with the co-accused. Therefore, for the same reasons as Michael, Jennifer is an affected child. Your Honour, Jennifer is unable to communicate verbally and can only communicate through sign language. Section 131A allows the court to order the state to provide an interpreter if they deem it necessary. As Jennifer is unable to communicate verbally, it should be deemed necessary by the court for a sign language interpreter to be appointed so that Jennifer can give an intelligible account of the events she experienced. As she is an affected child, like Michael, her testimony will be video recorded at a preliminary trial. Your Honour, my final submission today is that the video taken from Adam's iPhone should be admissible. It is my submission that public policy discretion should not be used by the court to deem the video inadmissible. When addressing this, the 5 factors set out in Punnings Bunnings v. Cross must be examined. The first factor is that whether or not the action was an honest mistake or a deliberate breach. Constable Smith obtained the evidence under by direction from Adam that the video recording was held on the iPhone. Therefore, it was an honest mistake by the officer and not a deliberate breach to not obtain a warrant. The second factor is that the contingency of the evidence has to be taken into account. The evidence shows the entire event on a video recording and could decide the case. Therefore, is very cogent. Factor 3 is, was this a genuine response to pressing circumstances? Adam had the capability to delete and alter the video. Therefore, it was a genuine response so that the evidence was not tampered with. The fourth factor is the gravity of the offence. The assault occasioning grievously bodily harm is a serious event and has a high weight of gravity. Factor 5 is whether or not a statute was breached. Section 150 of Police Powers and Responsibility Act was breached by the action. However, this was necessary in the circumstances to obtain evidence without tampering. On the balance of the factors, I submit that it is necessary for the court to deem the video recording admissible. Thank you for your time.